I'm going to give the last presentation, and this is from an attorney's perspective who represents whistleblowers. First, I'd like to say that, and I hope in the questions and answers more of this comes out, one of the very first cases that I won, and I actually counseled this with my brother Mike Kohn back in between '86 and '87, we actually won it in the press, literally. It was a case of an atomic weapons whistleblower at Savannah River site, Roger Wenzel, a great guy, and he blew the whistle on illegal drug use and some major safety issues in the construction of atomic weapons. And he was the first major national whistleblower at an atomic weapons site concerning health and safety. And what we learned very quickly was that the law for atomic safety excluded the weapons industry, so he had no rights. But he had an extremely interesting story and a lot of credibility. So we took it to, it was a journalist with the Washington Post, Cass Peterson, and she ran a really good story about his case. It was on page 3, excellent story. We weren't going to win anything, but the contractor overreacted and fired his #1 witness. So the firing of the witness then became a page 1 story in the Washington Post, and then continued coverage because of how just outrageous the contractor reacted to the story. So then the journalist confronted the Secretary of Energy at a press conference about what the Secretary of Energy was doing, which triggered an Inspector General investigation that eventually ordered the whistleblowers all to be reinstated with back pay. And I say this is, how do we know it was won in the press? Because Mike Kohn went down to a hearing in South Carolina for the whistleblowers. But the hearing was absolute sham because there were no real legal rights. So Mike went into it and he said, we want due process. We will not participate in a hearing without due process. And the hearing examiner said, well, this is our hearing. We're going to run the rules as we want to run it. Would you please have your whistleblower come in and tell us what happened to her? And Mike said, no, goodbye. He got up and left. So the whistleblowers never showed up at their own hearing, yet we won the case. Okay, that's a true story. They got reinstatement back pay because of the public pressure. And I will also state on the record that even if it's not winning a case, and that's the exception to the rule, I must say, don't think you're going to win your case that way, it can put pressure on an intelligent employer or government agency to back off. Because it's pretty much what Jim Popkins said, for the press to actually run a story, they will do and should do an extensive review and investigation. They have to check the credibility, the facts. They have to play the devil's advocate, and the whistleblower has to participate in that process. You know, you got to give them the good, the bad, and the ugly. You got to show them all the warts, all the weaknesses, and because if you can't essentially win your case with a journalist, you're not going to win it in court anyway, or you're going to have a tough time. So the journalist has to do their job, but once they run the story and stand behind, ultimately, those allegations, either implicitly or explicitly, but they viewed it as newsworthy, that can actually save the job of a whistleblower. Especially, unlike the contractors at Savannah River, if they realize that the reason it's in the press is because there's probably a lot of issues here they should be dealing with instead of firing and shooting the messenger. There's a second point I want to make, which I think is often lost. In the United States, I like to say this, we know there's no major, large whistleblower law, and that we often think that whistleblowers lack protections. But what I like to state is, I just got information. Believe it or not, Congress met in session, this is true, and passed a sweeping whistleblower law covering and protecting Americans to blow the whistle to the press. They did it unanimously, and they had such faith in our system They presented it to all the states to back it up too, and 3/4 did it very quickly, and they all signed on. It's called the First Amendment of the United States Constitution, the #1 whistleblower law in the world, and in our country, the #1 whistleblower law. Congress shall make no law abridging freedom of speech or press. That is the law of the land. And in 1968, the U.S. Supreme Court found that if you are a whistleblower working for the government and you blow the whistle to the press, you have constitutional protections and cannot be fired or retaliated against. Now, the gap between that constitutional principle and even those decisions and the reality is like the Grand Canyon. Only a twisted lawyer loving the most difficult arguments would think it's as beautiful as the Grand Canyon. But the gap is as wide as the Grand Canyon. The right and the implementation of that right. You literally have to hike down and hike all the way back up and hope you have enough water and you're well supplied. Because there is a right, but if you think that right's just going to come to you because the Founding Fathers wrote it in an important document, you are not living in the United States of America today. Their retaliation is the norm. Government officials who swear an allegiance to the Constitution forgot about the First Amendment, period. That's the reality. But because those rights exist, you will be surprised how far you can go. For example, in 1995, we surprised a significant sector of the national news media and most lawyers in Washington when we had an active duty FBI agent with top secret clearances that were so top secret he could not tell me what the clearances were, who was responsible for managing the crime scene in the first terrorist attack on the World Trade Center, who had detailed information about the Oklahoma City bombing case, and who was a supervisory agent within the FBI working there on those cases. And we asserted his First Amendment rights and eventually got permission for him to speak on television, criticizing the FBI on those terrorist cases and keep his job. Why? Because when push comes to shove, the First Amendment actually does exist. And it may take, you have to go to court, you may have to get an injunction, but there is such a thing as the First Amendment and it does apply. How many government officials have the audacity to assert those rights publicly? Very few. You can probably count them on your hands. And that's a shame because the public right to know is harmed. In the private sector, most courts will view blowing the whistle to the news media as a protected activity and try to get to get protection under statutes. Unfortunately, just recently, in February of 2010, a court in an unpublished decision went the other way. It was the first decision in a federal court that I saw going the other way. I think it's an outliner. I think it should be repealed and reversed. As I say, it's just a district court, so obviously there's now differences of opinion in the court system, but the good law and the majority of courts and agencies that have looked at it have found going to the news media to be protected under the normal whistleblower statutes. All of that being said, going to the press as a whistleblower is always, in my view, a radical step, because you have a chain of command, and did you exhaust it? There are government agencies often designed to get the information. Did you use them? Going to the press will open you up to heightened scrutiny, and it will open you up to the types of leaks, to the types of counterpunch that you heard from our speakers that a whistleblower can expect. Going to the news media is often the very end of the line, not the beginning of the line. That doesn't mean in law there's a difference, but in reality there is. there's an important decision from the United States Department of Labor that is still good law within the Labor Department, and it analyzed whether going to the press should be protected in the private sector. As we say, under the First Amendment, it should be protected for government workers, but should it be protected in the private sector? And the analysis was this: a whistleblower who goes to the government with an allegation of wrongdoing is protected. What about a whistleblower who goes to the press? Should they be protected? And the statute is silent. The statute says going to the government is protected. And what the analysis was, how do you get the government to take an allegation seriously? How do you actually make change in the United States? How do you force a bureaucracy to be responsive? And the analysis was by going to the press. A politician or a bureaucrat may ignore allegations of a whistleblower for years, but when they hit the newspapers, they have to take it seriously, often. And that's what happened in that case we did in 1986. The issues raised at Savannah River had been raised for at least 2 years. This guy had been hammered down. The Department of Energy had originally thrown his case out. The Department of Energy had lobbied against him. I mean, looking at his case in 1986, he was a loser because the contractor fired him and the local DOE office had slammed him down. But once the facts got out through the national news media and a new light was shed on it and pressure was put on the Secretary of Energy, it was all reopened, all reinvestigated. So it's clear, but had that whistleblower shown up to the Washington Post day one, there probably wouldn't even have been a story because he wouldn't have had a track record to back it up. So I think the good law is going to the press is protected. But the reality of the law is it's risky. In the private sector, unfortunately, you can't say with a certainty anymore whether it's protected or not, although the good law says it is. In the government sector, it should be, but reality is very different. I also want to state that no whistleblower laws currently protect the disclosure of secret or classified information to an unauthorized source. So even though the First Amendment says freedom of speech, that does not mean that that gives a whistleblower immunity for violating other laws that may be in effect. That could also include in the private sector rules on confidential business information, secrecy agreements, non-disclosure agreements, etc. There's a host of landmines, especially when you're going to the press. Why? Because if you blow the whistle in a letter, say, to an auditor, no one may actually see the letter. Your managers may know you were protesting a certain safety practice, but they may not know exactly what you said. But if something goes in the press, they can read what you said. They can refer it to the security office. They can refer it to their lawyers on trademark secrets. And if your name's associated with it, you may just have signed your employment death warrant. So going to the press has a lot of downsides, a lot of difficulties, but also can be the way to vindication or actually get the change. The bottom line is there are legal protections if you need to go to the press or go to the press, and those have to be carefully studied and implemented on a case-by-case basis with a lot of review and care. Finally, I'd like to say, and all the journalists here meet this bill, but you have to work with a journalist that understands the 6 rules that Mr. Solomon talked about, that is professional, will understand what a whistleblower goes through in both the vetting process and in their own personal lives. And there are a lot of journalists that do that, and I'm honored to have 3 of them here. So that is the legal summary.